Welcome to Epstein, Becker, Green's Employment Law This Week podcast. I'm George Whipple. The U.S. Supreme Court closed out its 25-26 term with a batch of highly anticipated decisions that limit the authority of quasi-independent federal agencies. The biggest impact is likely to come from Trump v. Slaughter, which addresses the president's ability to remove congressionally confirmed leaders. Today, we take a look at how the court's rulings are changing things at one such agency, the NLRB. Epstein, Becker, Green's Steve Schwersky works with clients that have union-represented employees and other business before the Labor Board. We asked him what impacts he expects from Slaughter.
What Trump v. Slaughter says is that they are not independent. What that means is that agencies like the NLRB, the board members, and the General Counsel are essentially at-will employees who serve at the pleasure of the president. They can be terminated at any time by the president for any reason or no reason. That is a monumental change in the regulatory state that has existed literally for 90 years. At this point, Trump v. Slaughter doesn't affect other positions at the NLRB or other similar agencies other than those that are presidential appointment and subject to confirmation. But it has the potential to have a significant trickle-down effect on those who report to either the General Counsel or the board members.
Traditionally, the NLRB has 3 members from the president's party and 2 members from the party that is out of power. But that is not mandated by statute or any regulation. We may see changes to this practice in the immediate future, with board member David Prouty, a Democrat, currently nominated for a new term. SCOTUS has been focused on agency authority for several years. Last term, in Starbucks versus McKinney, the court weighed in on the standard the courts use when the NLRB applies for Section 10J injunctions. Epstein, Becker, Green's Bill Lewis has some background.
Section 10J allows the board to seek a preliminary injunction in federal court to stop an unfair labor practice during the pendency of some kind of board proceeding. And so in Starbucks v. McKinney, the Supreme Court resolved a circuit split addressing the standard that courts should apply when reviewing applications for a Section 10J injunction.
Prior to Starbucks v. McKinney, some circuits, including the 6th, applied a less stringent standard that reduced the burden of proof for the NLRB. The Supreme Court rejected that standard and held that the traditional 4-part test should be applied to 10J. Now, in NLRB v. Trinity Health Grand Haven Hospital, the 6th Circuit has had its first opportunity to consider the issue post-Starbucks.
The 6th Circuit held that the regional director had failed to show that it would suffer irreparable harm without an injunction being granted. Specifically, in holding that, the 6th Circuit took the position that it was insufficient for the regional director to simply point to the fact that the employer was refusing to bargain in order to prove irreparable harm.
This appears to open up a new circuit split on the irreparable harm issue.
The 6th Circuit declined to adopt a presumption or a permissible inference of irreparable harm when an employer refuses to bargain with a union. This puts the 6th Circuit at odds with at least the 9th and 4th Circuits, which on this issue permit a permissible inference.
10J injunctions are considered an extraordinary remedy and used sparingly. Still, the issue shows us how the Supreme Court's push to limit agency authority and independence is playing out in lower courts, and the uncertainty that may be in store as the effects of decisions like Trump v. Slaughter are felt around the nation. Thanks, Bill and Steve. Thanks for listening. We'll see you next time.
This podcast is presented by Epstein, Becker, and Green, PC. All rights are reserved. This audio recording includes information about legal issues and legal developments. Such materials are for informational purposes only and may not reflect the most current legal developments. These informational materials are not intended and should not be taken as legal advice on any particular set of facts or circumstances, and these materials are not a substitute for the advice of competent counsel. The content reflects the personal views and opinions of the participants. No attorney-client relationship has been created by this audio recording. This audio recording may be considered attorney advertising in some jurisdictions under the applicable law and ethical rules. The determination of the need for legal services and the choice of a lawyer are extremely important decisions and should not be based solely upon advertisements or self-proclaimed expertise. No representation is made that the quality of legal services to be performed is greater than the quality of legal services performed by other lawyers.